Good afternoon, esteemed colleagues, and on the screen, esteemed speaker Sri S.C. Singh Sahab, Advocate, ex-Legal Advisor, Enforcement Directorate, and in the committee, the Secretary, Shalini Gulati. It is always a pleasure to hear a learned faculty having practical exposure like Mr. Singh. Friends, you will appreciate that money laundering has become a serious threat across the globe, and it's a threat to the financial system's integrity. It has emerged as a parallel economy operated by a few. It can destabilize the economy to that extent. Various governments have enacted their respective laws. In India, we have the Prevention of Money Laundering Act 2002, which is popularly known as Pmla, enacted by the government in 2005. All the Pmla cases are investigated by the Enforcement Directorate, known as ED. The ED has been given very wide power, and many a times in practical investigations, one wonders whether these powers are being utilized justifiably or not, whether the means and ways adopted are appreciable or not. But nonetheless, the consultant, the stakeholder has to deal with the same. And it is in such context that the person like Mr. Singh can throw many light, including how to deal with the same. All the cases investigated by the ED are ultimately filed in the special court, which deals with the ED cases. And thereafter, one may approach the High Court. So members are quite expert in investigative aspect as far as the financial expertise is concerned. But at the same time, one has to be coupled fully with the relevant provisions of the law, with the practicalities of the aspects, and how to deal with the factual issues. And for that, we have the learned faculty. I will, although the faculty is a regular one with us, but still, I will request Shalini to formally introduce the faculty so that the members can fully appreciate his standing. And then I also expect the members to actively participate, particularly in the question and answer session, which may be ensuing at the end. Thank you.
Thank you, sir. Sir Shri A.C. Singh, Advocate, is the former Deputy Legal Advisor of Enforcement Directorate. He enrolled as an advocate in 1983 and practiced as an advocate at Lucknow, both on civil as well as criminal side. He has worked as a prosecutor, Directorate for Prosecution, Government of NCT of Delhi. He has also worked as a special public prosecutor, CBI, at Lucknow, and conducted large number of prosecution under PC Act, IPC offences and others. He has worked as the Deputy Legal Advisor and overall in charge of the Legal Division of Headquarter Office of Enforcement Directorate at New Delhi. He has worked as a special public prosecutor, PMLA, and appeared before various high courts and Supreme Court. He was nominated by the Government of India and United Nations Office on Drugs and Crime jointly as government expert under the United Nations Convention Against Corruption Review Mechanism. He has reviewed the corruption laws of Republic of Korea, South Korea and Republic of Vanuatu under UNCAC Review Mechanism. He was the core group member of the Review of India under the UNCAC Review Mechanism, which took place in 2015. He has attended various conferences at Vienna, Bern, Switzerland, Seoul, South Korea, and Kuala Lumpur. He has attended the delegation of National Security Council at Bangkok, Thailand, to make the Thailand officials conversant with the Indian criminal law, including the Pmla Act. He regularly delivers lectures on Pmla at various state judicial academies, CBI Academy, as well as the Institute of Chartered Accountants of India. So over to you, sir, for your session today.
Thank you so much, madam. And today the session is I would call it a mega webinar, which has been organized by ICAI. And I believe that so many participants would be there online to attend it. And I will try my level best that let this webinar be very successful. With this hope, I start my address today. First of all, I would like to draw the attention of all the participants as to how this Anti-Money Laundering Act came into existence in India. And thereafter, I will tell you in short about the overview of the Act, and then I will come on the practical aspect as well as how it is the chartered accountants, what role they can play in preventing the Prevention of Money Laundering Act and make the Act very successful. So first of all, I would like to draw the kind attention of all the participants that so far as anti-money laundering is concerned, it is the United Nations, UNO, has decided that all member countries shall enact anti-money laundering law, and thereafter in India, this Prevention of Money Laundering Act was passed. It was passed in 2002. However, it got the assent of the President of India in January 2003. So therefore, the Act is known as Prevention of Money Laundering Act 2002, Act number 15 of 2003. And this Act was enacted with effect from 1st July 2005. Here I take a pause and I would like to remind all the participants that this anti-money laundering law, the present Prevention of Money Laundering Act 2002, the definition which has been provided under the Act, under Section 3. So, under that, this definition is a very long definition. It starts with the word whosoever directly or indirectly attempt to indulge or actually involved in any process, blah, blah. And in the end, and projecting or claiming it as untainted property. Thereafter, in 2009, some explanations have been incorporated. That apart. But here, I would like to draw your kind attention that it is the Palermo Convention. In the Palermo Convention, it was decided that all the member countries shall enact anti-money laundering law. And in that Palermo Convention, the UN has given the basic main ingredients of the definition of offense of money laundering. And according to the domestic law of each country, it was adopted, and thereafter the Act was enacted. Here, I would like to say that this law is altogether different from other laws of the country which are in existence as on date. I am saying so with a view that this particular law, the normal Indian laws are basically in all the offenses, the word offense has been described at 3 places in 3 laws, which under Code of Criminal Procedure, under Indian Penal Code, and the third one is General Clauses Act, where offense has been defined as any act or omission made punishable by law for the time being in force. That means precisely there must be act or there must be omission. Act, everybody understands. Omission, if you are traveling in a train, you are supposed to buy a bona fide ticket. If you have not bought the ticket, you are caught. It will be deemed as an offense under Indian Railways Act. So there is omission. So under all the laws which are prevalent in this country except Pmla, the definition of offence remains same. That is, and there is violation of act or violation of or omission. Here, under the Prevention of Money Laundering Act, under the definition which has been provided, if you look at the definition, it has been defined under Section 3 of the Act, which says that and projecting or claiming it as untainted property. That means the definition is in continuous tense. Here, I would like to draw your kind attention that this particular aspect, the developed countries, they have evolved the third dimension of the definition of the word offence. Beyond act or omission. What is the third one? That is the conduct-based crime. So the Pmla, the definition of money laundering is absolutely conduct-based crime, and that is why it has been mentioned in continuous tense. Because and projecting or so long as projection continues, the offence will continue. At that point of time, so many people, they have taken a plea that if scheduled offence has been committed prior to commencement of this act, what will be its impact? So on that aspect, in 2010, 6th August 2010, for the first time, the Honorable Jharkhand High Court had passed an order. In that case, what happened that one Mr. Hari Narayan Rai, who happened to be the cabinet minister of regime of Mr. Kora, he was charge sheeted by CBI for disproportionate asset case under Section 13(1)(e), read with 13(2) of Prevention of Corruption Act. This Section 13 came into existence with effect from 1st June 2009 through by way of amendment. He had taken the plea that he remained minister from 2005 to 2008. So therefore, this amounts to ex post facto law. All of you are aware that under Article 20, Clause 1, if no law shall be applicable from retrospective effect, it should always be prospective. In that case, when ED had filed a charge sheet, or in common parlance, they call it, in a statutory form, it is called criminal complaint under Section 45, read with 44 of Pmla. The other day it was challenged before the Honorable Jharkhand High Court. And the Jharkhand High Court had given the verdict saying that what it targeted, and please listen to my words, they are the extract of the judgment. They are being taken from the extract of judgment. What it targeted under Section 3 and another provision of this Act. What it targeted under Section 3 and another provision of this Act, the date of acquisition of proceeds of crime is not material. But what is material? Date of projecting it as untainted property. And I would like to tell to all the participants that this judgment had attained finality because it was never challenged. Recently, reached to Supreme Court on the aspect of retrospective. So, because acquisition of proceeds of crime is one part of the offense of money laundering, but the main offense is projection. Projecting it as untainted property. So it shall continue. One can have in possession of proceeds of crime prior to commencement of this act. Nonetheless, if he is projecting it as on date, he comes within the midship of the offense of money laundering. Secondly, since the definition has been given in the settled in the Palermo Convention, so you will come across so many words which are absolutely new in Indian legislation. Like, I would like to draw your kind attention towards the word indulge. Whosoever directly or indirectly indulge. In our country, whatever laws are applicable, the word indulge is not taken in good sense. But since it has been taken from the view from the Palermo Convention, therefore it has come. That apart, under Prevention of Money Laundering Act, one thing is very, very important, and I feel that very few people are aware about it, that as on date, globally, all over the world, two kinds of legal systems are prevalent. One is common law legal system. The common law legal system, what we have inherited from Britishers. If you look at Indian Penal Code 1860, Indian Evidence Act 1872, and so on. And as on date, this common law legal system is applicable only in southeastern countries, that is India, Pakistan, Bangladesh, Nepal, Bhutan, Sri Lanka. Even the Britishers, the UK, who had followed common law legal system, they switched over from common law legal system to civil law legal system. And for the last 45 years, they are adhering civil law legal system. As on date, all the developed countries are governed by civil law legal system. Here I take a pause and it is my duty to let you know that what is the basic difference between civil law legal system and common law legal system. In common law legal system, the cardinal principle of law is that accused shall be presumed to be innocent unless his guilt has been proved beyond all shadow of doubt. A. B. If an accused has been arrested, he cannot be detained in police custody more than 24 hours. Within 24 hours, he has to be produced before any magistrate, judicial magistrate, metropolitan magistrate, or in the hill areas where no judicial magistrate is available, the first remand of 7 days can be obtained even from executive magistrate. Such provisions are there under section 167, subsection 2 of CRPC. In common law legal system, a lowest level police officer is empowered to arrest a person. If we look at section 157 of CRPC, we will come across that the officer in charge police station on the basis of information means FIR, or otherwise has reason to suspect the commission of cognizable offense. He can depute his subordinate who will go to the place of occurrence, collect evidence and record statements, and if necessary, he can arrest the person. So, while arresting, any investigating officer is competent to arrest a person only on the basis of reason to suspect. Now, we come on the civil law legal system. In civil law legal system, the highest level of police officer is not competent to arrest a person. He can only arrest a person when the concerned public prosecutor has given his prior approval. Here I would like to remind you about the matter of Madam Devyani, who was Indian Foreign Service officer. And when she was arrested, prior to her arrest, Mr. Preet Barambara, who also happened to be a person of Indian origin, but he is a citizen of US, he was concerned public prosecutor. When he gave his prior approval, then she was arrested. So, there is 3 was difference between the two, and there is no condition. It depends upon country to country that within 24 hours he shall be produced for judicial. Secondly, in India, by virtue of Section 25 of Indian Evidence Act. What is Section 25 of Indian Evidence Act? No confession made before a police officer shall be proved against him. That means, even if a person is arrested and he says, I have killed Mr. X, nonetheless, that statement is only waste paper. It will have no legal sanctity attached with it. Whereas, in those countries who are governed by civil law legal system, even though the statement has been recorded by police officer, that statement shall be deemed as admissible piece of evidence. It can not only be used against the person whose statement has been recorded. If he has implicated other person, they will also be liable for the commission of the offense. So, in common parlance, I have tried to explain you the basic difference between two kinds of legal systems. In fact, under the Prevention of Money Laundering Act, there are so many elements which you can always find which relate to laws applicable in civil law legal system countries. And you will also find that the offense of money laundering is conduct-based crime. Why I am emphasizing conduct-based crime? Because somebody has generated money and supposing he has purchased this paperweight, he is not going to tell to everyone that I have purchased this paperweight out of proceeds of crime. But on the basis of his conduct, for instance, I would like to tell you that somebody has cheated bank, generated 1 crore rupees. With that 1 crore rupees, if he reaches the bank and tries to deposit in his account, immediately bank officer will ask what is the source of this money. And all of you are aware, KYC norms are there, he will be caught. But if he has opened 20 fictitious accounts and he deposits a small fragment of that money, so normally no bankman would put any finger on that money. Once it has been deposited, it is mixed up with the financial system of the country. And later on, he will withdraw the portion of the money or entire money, and from that money he goes and purchases some immovable property. Then again he disposes of that immovable property, and from that money he will purchase shares in the companies, and then he will sell off the shares of the companies. And from that money he has purchased a palatial building at some prime location of any district. So the people who are nearby his house will always think that he is a big person because he has layered the money at 4, 5, 6 times. So while conducting investigation, all these money, its roots are required to be surfaced. Then only it can be said that what is the origin of the money which had been generated. That I will come on the later part of my lecture. Here, when the Pmla was enacted, prior to one day, an amendment has taken place. Very few people are aware. And that amendment was made because the offence of money laundering had been initially mentioned as cognizable and non-billable. Now the question arose, if it is cognizable offence, then it is the statutory right of police officers to cause investigation as per the provision of Code of Criminal Procedure. Somehow the Government of India didn't want it to give it to police officers for its administration. So therefore they wanted to only employ or assign an agency who is not basically non-police organization. So therefore they have made amendment and brought section 45(1)(a). Section 45 within bracket 1 capital A, which says that no police officer shall be empowered to investigate the offence of money laundering unless there is a special order from the central government empowering the police officer to cause investigation. So therefore, the police officers have been debarred from investigating the offence of money laundering. And by way of gazette notification, the Enforcement Directorate was assigned this power because earlier they had been investigating PERA, which was also a criminal law, and they also investigate the contraventions under Foreign Exchange Management Act, which is also primarily a civil law. So they have been assigned the power to investigate under Pmla. Under Prevention of Money Laundering Act, 2 directors have been contemplated. It is also very important to know. One director is Director of Enforcement, who has been assigned the power to survey, seizure, attachment, launching of prosecution, etc. Whereas the another director who has been contemplated, he is called Director FIU, Director Financial Intelligence Unit. From section 11 to section 15, the Director FIU enjoys the power. Sometimes I have seen because I am in practice, when I was in service, I used to tell to my officers that they should always write. He was examined under section 50, subsection 2 and 3 of Pmla. But now they have changed the habit and they are writing that we have recorded the statement under section 50. That creates a confusion because under section 50, subsection 1, these powers are specifically meant for Director FIU for conducting investigation. ED officers cannot enjoy any power under subsection 1 of section 50. Anyway, under this act, the offence of money laundering has been given precedence over other laws by way of making this act an overriding effect under section 71 of Pmla. Then under this act, the special court, that central government in consultation with various chief justices of High Court notifies any court as a special court, and it will be session court, and the trial of the offence of money laundering is also session trial as provided under section 225 to 235 of Code of Criminal Procedure 1973. Section 225 to 235, the procedure propounded for the trial of the offence of the session trial. Why session trial? Because the offence of money laundering, although the punishment is up to 7 years in normal circumstances, but in respect of NDPS offences, it can go up to 10 years of rigorous imprisonment. Not less than 3 years rigorous imprisonment, and shall also be liable to fine. But keeping in view about gravity of the offence of money laundering, it was considered by the legislature that comparatively a very senior judge should be assigned the power to hold the trial of the offence of money laundering. And all of you are aware that in a session division, session judge is holding the highest. So therefore, these powers have been assigned to session judge to hold the trial. Under this act, there are 3 statutory presumptions under section 22, under section 23, and under section 24. Under section 22, and if during the course of survey such, and either under this act or under any other law for the time being enforced, it doesn't say that whether that particular contravention is governed by civil law or criminal. But if anything has surfaced, resumed, then it shall be presumed that that particular property, that particular writing is genuine, unless contrary is proved. So that means it is a statutory presumption. All of you are aware that 3 kinds of presumptions have been contemplated under Indian Evidence Act. One is may presume, shall presume, and the third one is conclusive proof. Under section 23, talked about interconnected transactions. As I have in the beginning of my address, I have told you that so many layering take place while committing the offence of money laundering. So, these layering, if the prosecutor is able to prove 1 or 2 layering, then further layering shall be presumed by the court, unless contrary is proved. And under section 24, if proceeds of time have been found, then it is up to the person. It is called in common parlance as reverse burden. But here one should not forget that initial burden lies with the law enforcement agency. He has to bring evidence that initial to discharge the initial burden. Under this Act, there are 3 schedules because this Prevention of Money Laundering Act does not apply in respect of all kind of laundering. There are specified offences. It is not like Anti-Money Laundering Law of Switzerland or Proceeds of Crime Act UK or US, where the predicate offences, all offences which are punishable more than 3 years, they are automatically treated as schedule as predicate offences. But in our country, the law says, law has prescribed 30 acts comprising 160 sections. If an offence has been committed in those sections and money has been generated, because why I am saying, I am emphasizing the word money has been generated, because section 302, that is murder, 307, that is attempt to murder, these sections are also there, and you know in our vast country, so many murders take place. So therefore, in every murder case, ED cannot step into, because unless there is evidence that there is generation of money or there is allegation of any supari killing also. In this act, there is also one more remarkable thing is there, that is if you look at the definition of the word property under section 2(1)(v), section 2, subsection 1, clause small v, which defines the word property. At the end, wherever found, located, wherever located. That means this particular provision has given this act a wide coverage, and it also goes beyond the boundaries of the country. And it has given, this act has been given transnational jurisdiction, which is unique in itself. Why it has been done so? Because presently Mr. Rukia has already pointed out that the offence of money laundering is a minor, and it generates parallel economy, and it has created a dent on the national fabric of national financial fabric. So therefore, the offence of money laundering, and all of you are aware that in WTC attack, it was the laundered money which had been, the money which had been generated through narco terrorism. So therefore, the offence of money laundering needs to be curbed if one wants the progress of the country. Under Chapter 9, starting from Section 55 to Section 61, under this Act, it provides reciprocal arrangements. Prior to commencement of Pmla, there was only one provision in the form of Section 166A, which dealt with outbound LR, letter of request, and 166B of CRPC for inbound LR. Whereas under Section 57 of Pmla, it has given power to a special court to issue letter of request, but a condition has been imposed by legislature when a special court is satisfied that certain information from any contracting state is necessary for the purposes of investigation, it can be done. Secondly, under this Act, under Section 61, the property, under Section 60, a property which is lying outside India can also be attached by way of issuing provisional attachment order. And once it has been confirmed by adjudicating authority, it has to be sent through the route of letter of request or LR to that country, and that country shall treat it as if the order has been passed by their own agencies or their own judicial system, and that will be complied with, and that attachment will take place outside India. So therefore, this Act has been assigned transnational jurisdiction. Secondly, under this Act, Section 65 is there, which says that all the provisions of Code of Criminal Procedure shall be applicable unless it is inconsistent with the provisions of this Act, that is Prevention of Money Laundering Act. So now I have given a broader outlook, overview of this Act. Now I will come on investigation. Whatever are your questions, please submit it to Madam Shalini Gulati, and I will devote at least half an hour to solve your queries and doubts. How the investigation takes? Because so far as Prevention of Money Laundering Act is concerned, it is not an original offence. The original offence is scheduled offence. It is presumed that if scheduled offence has been committed and that scheduled offence generated money, so that money should be trailed and it should be sealed, frozen or attached, so that no laundering could take place. As all of you are aware that the money laundering takes place in three ways. One is placement, the second one is layering, and third one is integration. Although there are examples where directly third stage comes, because the money has been sent outside India by way of Pmla, and from that money the money was invested in buying immovable properties and all. That apart, normally it is the three ways through which offence of money laundering is committed. And what is laundering? All of you are aware that is when the person who has generated any ill-gotten money, which is called proceed of crime under the Pmla, that proceed of crime by way of layering and all, its actual color is basically rubbed off, and the actual color no longer remains in existence. As if you recapitulate your memory, in the beginning I had told that somebody had cheated the bank, generated 1 crore rupees. How the money was siphoned off, how the money was deposited in various bank accounts in small fragments, and later on it was withdrawn, then it was invested in buying immovable property, then that immovable property is again disposed of, and the money was pumped in purchasing, buying shares and all, and later on shares were also sold off. From that money, the property has been, some palatial building has been purchased. So every individual will think that he is a big man because anybody asks him, he will say that I had sold the shares, these are the shares at killed, and I got this money. So nobody would like to enter into so deep to reach to the actual source, origin of the money. So that origin of money is totally obscure. The intention is to keep to obscure the origin of money so that nobody can touch and nobody can assess whether it is laundered money, because it should look like that it is a genuine money. That is precisely the offense of money laundering. Now I am coming to practical aspect. So I had told you that in India, the offense of money laundering is not original offense. That is why it is called the secondary offense. And I would like to draw the kind attention to all the participants that, of course, these days you would have seen that CBI and ED, they are investigating side by side and all. But I am afraid tomorrow, if the scheduled offense is closed, what will be the end result of offense of money laundering? Because ED has got the power to investigate Pmla. Supposing that CBI has registered the case under section 120B, 420, 467, 468 and 471 of IPC. When they conducted the investigation, they found out that no offense has been committed. They are bound to file final report. So once the offense of scheduled offense is not on board, how the offense of money laundering will be treated? Because scheduled offense must have been committed. In this way, I can say that for offense of money laundering, there must be an underlying scheduled offense. Unless and until there is underlying scheduled offense of money laundering can never take place. Somebody has generated 500 crore rupees in indulging in gambling. Whether ED can attach the property? The answer is big no, because Gambling Act is not a scheduled offense. So therefore, and as on date, it has become, I would like to tell you about two judgments. One judgment of one Babulal Verma case of Bombay High Court, where Honorable Bombay High Court single judge has held that ED requires only FIR. Even afterwards, the FIR is quashed, accused persons are discharged or accused persons are acquitted, it shall have no bearing on the offense of money laundering. I am afraid, although that judgment I don't know whether it was challenged before Honorable Supreme Court or not. This judgment was pronounced way back in February 2021. In July 2021, in the case of Madhu Kaneru, the Honorable Telangana High Court, in that case, I just give you a brief fact. In that case, what happened that the accused was prosecuted by CBI, but he was honorably discharged by the trial court. And CBI accepted that order was never challenged. ED had also filed the criminal prosecution complaint. He went to High Court. His contention was that unless until there is underlying scheduled offence, there can't be offence of money laundering. The Honorable Telangana High Court quashed the prosecution and held that it amounted to abuse of process of law under section 482 of CRP. Recently, on 4th January 2022, there one matter came up before Honorable Supreme Court. The name of the case is Assistant Director, Enforcement Directorate versus Dr. V.C. Mohan. Assistant Director, Enforcement Directorate versus Dr. V.C. Mohan. In that case, what happened that the Andhra Pradesh High Court had granted anticipatory bail to Dr. V.C. Mohan. ED filed SLP on being agreed by the order of granting anticipatory bail to Dr. V.C. Mohan. The Honorable Supreme Court quashed the anticipatory bail order of the Honorable High Court and remanded the matter back to Andhra Pradesh High Court for deciding afresh. However, in paragraph 3 of the order dated 4 January 2022, the Honorable Supreme Court has said, indeed, please mind my words, indeed the offence of money laundering is dependent upon predicate offence. Indeed, the offence of money laundering is dependent upon predicate offence, although that was not in issue. Yet, even if it is obiter dicta, but since it has come out from the mouth of Honorable my Lord, it must be given weightage. And I tell you that presently there are large number of petitions which are pending before the Honorable Supreme Court, and I have come to know that proceedings are going on where it has to be decided about when there is no scheduled offence, whether Pmla can be applicable or not applicable. But I am afraid, because as per the concept which has been created by the framers of the Pmla, unless and until there is underlying scheduled offence, there can't be an offence of money laundering. So, how the investigation takes place, so there must necessarily be commission of any scheduled offence. How the scheduled offence has been committed, if it is being investigated by police organization, then they will definitely register FIR. Because all these offences are cognizable as per paragraph 1 of part A of the schedule. FIR has been registered. If it is being investigated by non-police organization, because I give you an example, the offence of under NDPS Act, serious crime, serious offences, very severe punishment that has been provided under NDPS Act. It can be investigated by police. It can be investigated by CBI. If either police or CBI have registered the case, they will register an FIR under section 154 of CRP. But same offence can also be investigated by DRI, Directorate of Revenue Intelligence. The same offence can be investigated by NCB, that is called Narcotic Control Bureau. If I just want to recapitulate your memory about the decision of Honorable Supreme Court in the case of Tufan Singh, the judgment came only last year. In the case of Tufan Singh, Supreme Court has held although the NCB officers are not police officers, nevertheless, they enjoy same powers like a police officer. So therefore, the statement which has been recorded, the confession which has been recorded by NCB officer under section 67 of NDPS Act shall not be an admissible piece of evidence. So many people started questioning if NCB officers who are not police officers if they have recorded the confession, it has no value in the eye of law. So on the same pattern, the ED officer, when they record the statement under section 52 and 3, it should also be hit by the Tufan Singh judgment. But there is some difference. If you look at section 67 of NDPS Act, it only talks about recording of a statement. Whereas you read section 50, subsection 2 and 3 and 4, you will come across that by virtue of section 193 of IPC and 228 of IPC, such a statement shall be deemed to have been recorded in a judicial proceeding by deeming fiction. Such judicial proceeding has been carved out under that. On the same analogy under section 108 of Custom Act. On the same analogy under section 40 of FERA 1973, which has since been repeated, there is one judgment of Honorable Supreme Court, although that was in respect of FERA, Foreign Exchange Regulation Act 1973, but that gives a very wide picture. The name of the judgment is Naresh J. Sukhwani. Naresh, Naresh, J for Jug, and Sukhwani, Sukhwani. In that judgment, Supreme Court has held in para 4 that the statement recorded by enforcement officer is not a statement cannot be equated with the statement recorded by police officer under section 161 of CRP. Because the statement recorded under section 161 of CRPC can only be used for the purposes of confronting the person when he appears before the court of law as a prosecution witness. Whereas the statement recorded by ED officers, enforcement officers under section 40 of FERA, such a statement by virtue of deeming fiction shall be deemed to be a substantive piece of evidence. It can not only be used against the accused but also against his accomplices. So that is why, because of under section 67, there is no deeming clause, no deeming provision of judicial proceeding. Whereas under section 50, subsection 2 and 3 and 4, there is a deeming clause and there is a specific provision that these proceedings shall be deemed to be judicial proceedings but for limited purposes. Only for the purposes of section 193 IPC, 193 is perjury and 228 of IPC, 228 causing disturbance in the judicial proceeding. So, what is the mode of investigation which is normally done by the ED officer? They first of all call the person by way of issuing summons. When a person appears by way of summons, in which it has been very specified as to place, time when he has to appear, and the power for issuing summons, the lowest level officer is assistant director. So no officer, no executive officer below the rank of assistant director can issue summons under the Prevention of Money Laundering Act. If he has issued a summons to any person whom he will issue the summons, it is not like that he will issue summons to Chief Justice of India. In lighter way, I am saying, he has to issue a summons to a person who is acquainted with the facts and circumstances of the case. You can equate it with Section 160 of CR. Under Section 160 CRPC, police is officer who is investigating the case is required to issue written order. There, under CRPC, power to summon a person lies with the court. The police officer issues written order. To whom? To a person acquainted with the facts and circumstances of the case. To appear. When he appears, his statement is recorded. Have you ever thought of why he is asked to write the statement? Despite these days, computer and is there, but the person who has been summoned is asked to write in his own handwriting. In this regard, I would like to refer one judgment of Honorable Supreme Court. In the case of Sampat Kumar versus Enforcement Directorate. Sampat, S-A-M-P-A-T-H, Sampat Kumar. This judgment is of 1994. If you go on Google, you can take that judgment. It was decided by Supreme Court. Honorable Supreme Court has said that if a person who has been summoned is asked to write the statement in his own handwriting, it avoids any kind of duress coercion upon such person. Because he can deny, he will not write. If he has written something, it shall be presumed that he has given voluntary statement. So that is why he records that statement. Then they have the power to conduct survey. Survey, all of you are mostly chartered accountants are well aware, 133 of Income Tax Act. They can go to the place, but they can only earmark. They will not take the property. Whereas under Section 17 of Pmla, searches can be conducted. An officer not below the rank of deputy director can authorize any officer subordinate to him to go and conduct search. While conducting search, the provisions of Section 100 CRPC, 100 of CRPC shall be applicable. Section 100 CRPC clearly stipulates that there must be 2 or more respectable persons of that locality. Here I take a pause. Why did the legislature use the word respectable person? This issue came up before Honorable Supreme Court, that all citizens are alike. So why legislature has mentioned respectable person? Then the Supreme Court aptly responded. They say, supposing the witness is a rickshaw puller. From one passenger, he may charge 5 rupees. Whereas from another passenger, he may charge 10 rupees. or from third passenger he may charge 2 rupees, and so on. He can change, vary his rate from time to time. So therefore, legislature has deliberately used the word respectable person so that the investigating officer cannot pressurize them to sign on that. I have also worked with Central Bureau of Investigation in CBI. When they go for conducting such, they call 2 officers from another department. So, because so many times the people do not want to take part in the such proceeding and all, they say that unluckily we will be victimized. But law says there must be 2 respectable persons. That has been mentioned under section 100 of CRPC. Under section 17(1)(f) is very important. Why it is important? This is the only provision under which the statement shall be recorded on oath. Under section 17(1)(f) of Pmla, any person who is found in possession of proceeds of crime or property involved in the offence of money laundering, his statement may be recorded by the person who is conducting the such statement shall be on oath. So, such seizure, freezing, that is under section 17(1)(a), it can only be used in respect of movable properties and especially bank accounts and all, where such is not possible, and very simplified procedure has been prescribed under section 17(1)(a). But for following section 17(1)(a), the investigating officer is supposed to follow the procedure prescribed under 17(1). That means a search warrant is to be issued, and pursuant to such warrant, the person investigating officer shall have to give opinion that this relates to bank account and it is not feasible to seize any bank account. So therefore, a simple order letter shall be issued to the concerned bank manager that this amount, this particular account has been frozen. And then the procedure that has been prescribed under section 8(1) before by adjudicating authority, that had to be followed. Here, I would like to draw your kind attention that recently one judgment of Supreme Court has been drawn. In 2021, the name of the judgment is Opto Circuit Private Limited. Opto Circuit, OPTO, all in capital. Opto Circuit Private Limited. In that particular case, the Supreme Court, what happened that the ED officer in Bangalore, what did they do? They issued a letter mentioning debit freeze account. That means credit will take place, but no debit will be permissible. This procedure, this kind of practice was going on. When matter reached before Supreme Court passed the order. They quashed the debit freeze letter of ED officer, saying that if there is a special law and and if it provides a special procedure, only such procedure shall be followed and none else. And the Supreme Court has also followed the judgment of its earlier judgment of Brij Kishore, where same thing has been uttered by Honorable Supreme Court. So, therefore, because Act says there should be freezing order. Act says within 30 days they have to pass an order, issue a original, they have to file the application which is called original application before adjudicating authority under section 17 subsection 4 of the Act. But that has not been complied with, that has not been followed. Here I would like to invite your attention towards section 4 subsection 2 of CRPC. Section 4 subsection 2 of CRPC. What does it say? Subsection 1 of section 4 of CRPC clearly stipulates that all investigation, inquiry or trial in respect of IPC offences shall be conducted in accordance with procedure laid down under Code of Criminal Procedure 1973. Subsection 2 says if there is any local or special law and if it provides a special procedure, then such procedure shall be followed. The provisions of CRPC shall be eclipsed to that extent. Same thing has been mentioned under section 65 of Pmla, that all the provisions of CRPC shall be applicable unless it is inconsistent with the provisions of this Act. I would like to give you an example. In one case, some ED officers, they issued an order under section 102 of CRPC. As all of you are aware, police has got the power under 102. And they were saying that it is the interim measure to protect the property. Some shares were withheld by way of issuing an order under 102 CRPC. The Delhi High Court deprecated and said that under section 102 of CRPC, subsection 3 clearly stipulates that it has to be produced before the magistrate. The magistrate having jurisdiction. Under Pmla, it is the special court, which is the trial court. So therefore, there is apparent inconsistency. And they set aside that order. So, I am coming back to the procedure which is being followed for the purposes of conducting investigation. One more provision is there, that is the power to arrest under section 90. Under section 19, ED officer, there was lot of hue and cry. Is still there. Whether the offence of money laundering is cognizable or non-cognizable, bailable or non-bailable. But the crux is the cognizable, whether offence is cognizable or non-cognizable, bailable or non-bailable, are meant for police officer while conducting investigation under Chapter 12 of the Act. Chapter 12 starts from section 154 and ends at 173. Technically, 174, 175, 176, that is inquest proceeding. So we are not concerned about that. That is unnatural that police conducts inquest report, prepares inquest report. We are only concerned about investigation being carried out by police officer under section from section 154 by registering FIR till he files the final report disclosing the commission of offence. In common parlance, it is called charge sheet, but technically it is called police report under section 173, subsection 2 of CRPC. So, whether the offence of money laundering is cognizable or non-cognizable, basically the ED officers are not police officers. The answer is very simple. They are not police officers. Why do they make arrests? They have been assigned a specific power under section 19. And those powers are quite distinct and different from the powers enjoyed by police officers while arresting a person. A police officer can arrest a person merely on the basis of reason to suspect the commission of cognizable offence. Whereas ED officer not below the rank of assistant director, he can arrest a person. A, that he has reason to believe to be recorded in writing. It is not like that. Dimag mein ji, I have taken decision, mere dimag mein. No. You have to form reason to believe. And Act says, section 19 says it has to be recorded in writing. And to what extent? To the extent that the accused is guilty of the offence of money. So that means the guilty is some clinching evidences must be on record. Police, they can arrest on basis of reason to suspect. Sometimes they have the power, somebody is not complying their written order issued under 160 to go and arrest. But under section 19, the assistant director or above has power to arrest a person when they have reason to believe. Reason to believe to be recorded in writing. To the extent that he is guilty of the accused is guilty of the offence of money laundering, then only he can go and arrest a person. Irrespective of it, whether offence is by cognizable or non-cognizable, bailable or not bailable. Then once he is arrested, because there are two judgments of Supreme Court, one judgment is old judgment of 1994 of Deepak Mahajan, where Supreme Court has said that ED has got the power to seek remand under section 167 of CRPC. I believe every participant is aware about it because all of you are CAs. But for the sake of convenience, I would like to tell you that the issue was in the Deepak Mahajan judgment was that section 167 of CRPC clearly stipulates that the magistrate, on the basis of entries made in the case diary, remand the accused either to police custody or otherwise than in police custody. Forget about judicial custody. These days, I am sorry to say that so many people, remand JC hai, they say judicial custody, whereas law says it is police custody when the accused will be handed over to police, or otherwise than in police custody. Why legislature has used the word otherwise than in police custody? If he is all right, he will be sent to jail. That will be called JC. If he is unwell, he will not be sent to jail. He will be sent to hospital. If he is mentally retarded, he will be taken to mental asylum. If the accused is a woman, she will be taken to Nari Niketa. So that is why the word used is otherwise than in police custody. Judicial custody is one of the fragments of that. So the issue before Supreme Court was as to how, because ED officers, they are not police officers, they don't comply, they don't conduct investigation in accordance with Chapter 12 of CRPC. And the case diary is maintained by virtue of Section 172 of the CRPC. And ED officers don't conduct investigation in accordance with Chapter 12 of CRPC. So issue came up before Supreme Court. So then Supreme Court said, if we give this kind of analogy, then the whole purpose of providing power to arrest a person to the ED officer or for that matter any law enforcement agency would be defeated. Because if they have arrested, on the other hand, then the magistrate will discharge them on the ground that they don't maintain case diary, therefore the magistrate is helpless. Then the Supreme Court said, although the ED officers who are not police officers, they are not conducting investigation in accordance with Chapter 12, nonetheless, they maintain a case file and the learned magistrate can peruse the entries into a case file and then come to a conclusion whether the accused should be remanded to ED custody or jail custody. So, and recently in Pmla case, more judgment came in 2018. The name of the judgment is Om Prakash Agarwal. Om Prakash Agarwal. I will just tell you about the correct name, but as far as I remember, it is Om Prakash. First two names are Om Prakash. 2018 Supreme Court. In that case, Supreme Court has categorically held and they followed the judgment of Deepak Mahajan and they said if ED has arrested a person under Section 19 of Pmla, then the magistrate is empowered and to exercise the power under 167 subsection 1 as well as subsection 2 of CRPC. So therefore, the default bail is also available to a person who has been arrested by ED officer. That if no investigation, he remained in custody more than 60 days and no charge sheet or complaint has been filed, then accused shall be released on bail. Now I am coming up. When the investigation, if you happen to see the summon, when ED officers, they summon a person simultaneously to call the person to produce the certain document, like ITR, 10 years income tax return, and then bank accounts, movable, immovable properties and all. Because, as I have told you, it is conduct-based crime. It is not a conventional crime that murder has taken place, so then you will go there and conduct Naksha Nazari or site map, plan and other things. Here it is conduct-based crime. So therefore the IU called the person to appear his evidence is, his statement is recorded. Once a statement has been recorded, then if necessary, his such premises are such, because sometimes some documents are recovered and seen. Secondly, from practical point of view, I have seen that the chartered accountants, they always take part in the preparation of audit work. They facilitate the balance sheet of the company and all. I had come across in one big case that company had got prepared two balance sheets. In one balance sheet was true balance sheet, on the basis of which he filed the income tax return. There was another balance sheet that was rosy picture balance sheet that was prepared for the purposes of obtaining loan. Because at that point of time, now I think it has been changed. At that point of time, I'm talking about 2010, 2011, there was no coordination between income tax authorities and banks while granting loan, sanctioning loans. So I found usually two kinds of balance sheet were got prepared. And so here I would request my all professionals that they should perform their duty diligently and ethically. Because of this thing, if they have been assigned the power to conduct to examine the balance sheet, to examine the account, to prepare the account of individual or company. And he should not take part in nefarious activity, because I have come across that so many times some professionals are involved in providing accommodation entries. You go with cash to certain companies and they will give you issue certificates and all, share certificates and all. So they should avoid this kind of activity. If they highlight all these things, then there are chances that the offense of money laundering may not be committed by such persons, by like-minded persons. They do it when they get support of professionals. So my view is that because they are doing the account work of the company and all, and they should remain truthful and highlight if they come across that there are certain discrepancies, then that should be brought on record. Because of this thing, the definition of money laundering is very, very wide. I am again telling you, whosoever directly or indirectly attempt to indulge or actually involved in any process or activity. So according to Indian legal system, an offense can be committed in four ways. First one is intention. Intention has never been a crime. One has the intention of doing it, so long as it remains in the heart. Then the second stage is preparation. Under the Indian Penal Code, preparation has been made punishable at 4 different places. preparation to commit dacoity, preparation to wage war against government of India, preparation to secede territory out of India, and the last one is preparation to counterfeit currency note, banknote. But in a special law, preparation has also been made punishable, like Pmla. What is process or activity? This is all element of preparation. And the third stage is attempt. Attempt has been made punishable everywhere, whether Indian Penal Code. Under Indian Penal Code, there are certain provisions who specifically are meant for attempt, like attempt to murder, attempt to commit culpable homicide not amounting to murder, under section 308 of IPC. And if it is not there, then all attempts are covered under section 511 of IPC. That is the last section of Indian Penal Code, 511. Here, under the Prevention of Money Laundering Act, if you happen to look, section 3, it talks about abatement. It talks about an abatement takes place in 3 ways. Under section 106. I am sorry, I stand corrected. It is 107 of Indian Penal Code. There are 3 ways to commit abatement. Abatement by aid, abatement by instigation, and the third one is abatement by conspiracy. So abatement is there, conspiracy is there, preparation is there, and attempt is there. That has been mentioned, attempt to indulge or actually involved in a penny process or activity. So the ambit and the scope of section 3 is very large. I am practicing as an advocate. Sometimes few professionals come to us and they say, Kitabo, I have signed. So I would like to give my advice to my professionals that while signing any document, they should be very clear. It should be thoroughly checked, properly seen, and then only it should be signed. So many times I have seen that it has been signed by professionals. I would not name. And the professional has signed it where in that there was no signature of the person in the vouchers. So they should avoid. And you must be very careful, because what for you are performing your duty. If these are the basic function of a professional, to be very diligent. You have done you have put in so much labor in obtaining the degree of chartered accountant. It's not an ordinary thing. So you must perform it well. I have seen so many cases while I was serving in the enforcement directorate that so many chartered accountants, they were found involved. Even in one case, I found that the gentleman, he himself opened so many fictitious companies to launder the money, shell company, for the benefit of the actual company. So these are the things one should keep away, and proper auditing must be done, and please don't allow any of your client to hide you from your professional ethics, and always be cautious. That I just remember one Honorable Supreme Court judgment when Honorable the then Chief Justice of India, Justice J.S. Verma, in the case of Vineet Narayan, had said, be you ever so high, be you ever so high, law is above you. I am repeating, be you ever so high, law is above you. So ultimately, law is to be administered, followed, not a big person or any person claims that he is a big man. That is of no use. With these words, because it is about 5:45, I have to take question answer. So I would like to invite Madam Shalini Gulati she must have kept so many questions. So now I am ready to face the volleys of your questions. So, Madam, please ask whatever questions, queries you have come across. I am ready to reply.
Sure, sir.
Yeah.
Sure, sir. So my first question is, can you please tell in simple terms what is money laundering?
What is money laundering? The money laundering is basically a process through which any ill-gotten money is converted into a genuine money by way of by applying the layering. I have given example, somebody has cheated bank, generated 1 crore. If we go to the bank with 1 crore rupees to deposit it, the bank will inform to police. So, but if he has got open 10, 50 shares account and deposits in that amount in a small fragment, then the bank will accept. Later on, he withdraws that money. From that money, he purchases some immovable property. Then again, after 6 months, he disposes of that property. And the money which he has got, he purchased shares, invested in shares. Then he sold off those shares. And money we got, he bought a palatial building for himself. Now everybody who is residing nearby will think that he is a big man. Because if somebody asks him, where from you got this money to buy this huge building, he will say, I had so many shares with so many companies, I have sold them. These are the shares, with this money I have got it, that money has come through bank. So, the origin is doubtful. But for reaching to origin, so many layering has taken. So when investigator goes on and then he opens the layer by layer, then that is why under section 23, interconnected transactions, the Act provides that if 1 or 2 interconnected transactions have been proved, remaining shall be presumed to be true.
Okay, sir. So I move to the next question. The next question says that accused has admitted some guilt before Enforcement Directorate in his signed statement. Is it admissible in the trial of the main IPC case for the scheduled offence also, if the IO of that IPC case files it as an evidence in the court?
Okay, madam. Good question. Madam, kindly convey to them. If a statement has been recorded under a special law, it can only be applicable in that particular law. You cannot apply it in any other case. Like on this, the viewer, you just respond to viewer that it is a judgment of Honorable Supreme Court in the case of KTMS Mohammed. KTMS Mohammed. I give you an example. In that particular case, what happened that ED has investigated recorded the statement, and later on ED could not make out a case, then they referred the matter to income tax. Income tax also has got the power under 131 of Income Tax Act. When they recorded the statement or note, he retracted his statement given before enforcement officer. Income tax launched prosecution of perjury under section 193 IP. That before ED, he has given this statement, which has been recorded in a judicial proceeding. And in 131 statement, he has totally retracted. Then what happened? Matter went to Supreme Court. Supreme Court said that if a person has given a statement under one statute, he has given his statement pursuant to main object of that particular act. It cannot be used in any other law. Like my friend who has asked the question, you just please convey, or if he is listening, he must be listening me, that if an accused has made confessional statement in a Pmla statement, it can only be used in Pmla proceeding. It can never be used in IPC trial. It can never be used because he has made the statement pursuant to main object of Pmla. He has not given a statement in Indian penal. Is it clear, madam?
Okay, sir. Sir, I'll go to the next question.
Yeah.
It says, yes, sir. So I'll move to the next question. It says, prior sanction is required to prosecute a public servant under Section 19 of PPA and Section 197 CRPC. Singh versus State of Punjab, which has held that protection of Section 1 sanction under 197 CRPC will not be available for offences under Section 120 IPC, fabrication of false records, bribing, cheating, etc. And such offences have no nexus with the performance of the official duties. So whether sanction is required for the prosecution?
Madam, look here. For the purposes of Indian Penal Code, the sanction is required under Section 197 CRPC. Section 197 CRPC clearly says who is or has been a public servant. Who is or has been. That means it gives protection to former government servant, public servant. And who are public servant? Who have been defined public servant under Section 21 of Indian Penal Code. Section 21 of Indian Penal. Whereas under Prevention of Corruption Act, Section 19, sanction is required to be given, to be obtained by investigating agency, because Section 19 of PC Act clearly stipulates that no special judge shall take cognizance of the offence under Prevention of Corruption Act without obtaining sanction for prosecution by appropriate government. What is appropriate government? If he is a central government employee, it is central government. It is if he is central government employee, the central government. If he is a state government employee, state government, or any other authority, statutory body. And Supreme Court has time and again has held that who is the appropriate authority? Appropriate authority means the officer who enjoys the power to dismiss that particular public servant accused. He will be appropriate authority.
Okay, sir.
I think that was your precisely question?
Yes, sir.
So that is why sometimes it happens that CBI invokes 120B, 420, 467, 468, 471 and also 131D read with 32 of PC Act. Then the sanction is required for cognizance purposes under PC Act of Section 90 for 120B IPC offences 197. Section 197 sanction will be obtained from state government, whereas under PC Act appropriate government. Yes, ma'am.
Okay, sir. So the next question is, if you could enlighten if there is any time frame limitation to complete any inquiry initiated by Enforcement Directorate. So whether there is any time frame limitation to complete any inquiry initiated by Enforcement Directorate.
Madam, look here. The first and foremost, take the example of Code of Criminal Procedure. Under CRPC, it has been contemplated that...
Sir, am I audible?
Yeah, you are.
Sir, am I audible to you?
Yeah, you are audible. Should I continue? Hello? Akash? Continue. I am continuing. Under Code of Criminal Procedure, it has been contemplated that investigation must be complete within 24 hours. However, when there are wide ramification and all, investigation cannot be completed within 24 hours, then the law provides that within 60 or 90 days if accused has been arrested. Within 60 days or 90 days. If the offence is punishable up to 10 years, then 60 days. More than that, life imprisonment, death sentence, it will be 90 days. If investigation has not been completed, accused will be granted default bail. Now under Prevention of Money Laundering Act, same formula also applies that if accused has been arrested under Section 19 and he remained in custody and within 60 days no criminal complaint has been filed, accused shall be enlarged on compulsory bail, default bail under Section 167, subsection 2 of CRPC. Now I am coming to your second part. If accused has not been arrested, there is no time frame. Please ask the participant that kindly open Section 468 of CRPC. Section 468 of CRPC. Section 468 of CRPC says that the offence is punishable with 6 months. The court will take cognizance within 6 months. If the offence has been committed having 1 year imprisonment, the cognizance period would be 1 year. If 3 years, up to 3 years. More than 3 years, there is no outer limit for taking cognizance. That means if there is no limitation attached with taking cognizance under the Code of Criminal Procedure, so that investigation may continue. And there is no legal bar. Although justice delayed is justice denied, but I have worked for 7.5 years as special public prosecutor, CBI. I have conducted large number of cases. And I tell you, in 1998, before joining ED, I had concluded a case in which charge sheet had been filed in 1967 after 31 years. But because it was a fraud case and document based, so man can forget, man because of his memory fades, but document does not. So it goes on. But now we should make everywhere the Honorable Supreme Court has said time and again that it amounts to attack on right to life or personal liberty. But same right to life or personal liberty under Article 21 says, no person shall be deprived of his life or personal liberty except according to procedure established by law. And that procedure has been further that established by law has been elucidated by Honorable Supreme Court in the case of Maneka Gandhi case, where they said there must be due process of law. Then again interpreted that what amount to due process of law. That means it must be just, fair and reasonable.
Yes, sir. Sir, I'll go to the next question. It is regarding a property that has changed hands several times, and one of the earlier purchasers has been charged under Pmla that the purchase was made from proceeds of crime. Now, what is the status of the chartered accountant of the last purchaser?
Madam, look here. According to me, all these purchasers, except the original one, they are innocent buyers. Because they are bona fide purchasers. If they have purchased the property, here I would like to draw your kind attention towards the judgment of Bombay High Court, Honorable Bombay High Court. That judgment was written by present our Supreme Court Judge, Mr. Justice Khanwilkar, in the case of Radha Mohan Lakhotia, RADHA Radha Mohan Lakhotia. It was decided in 2011 by Bombay High Court Division Bench. In that case, Honorable Bombay High Court has said that proceeds of crime, wherever available, are liable for attack. But the person from whose possession such proceeds have been recovered are liable for criminal prosecution or not shall depend upon whether they were holding it knowingly, they are liable for prosecution. If they were holding it unknowingly, they will not be liable for criminal prosecution. Here, one more thing comes into question, because supposing that property was sold by, purchased by main accused, and later on it was sold to X, then Y, then Z, and now it has been attached from Z. But the investigator must go to the original accused, because he has got the value of that property. He will continue. What is the main object of Pmla? An act to prevent money laundering by confiscating the properties involved in the offense of money laundering. If you run on the property only, you are allowing the accused to enjoy the proceeds of crime, because the property, when he purchased, he spent the money, then again when he sold, he got back the money, and he will continue to launder. So the whole object of the act would be defeated. So instead of attaching that property, they should attach the money from the person accused.
Okay, sir. So the next question is also regarding a property purchase. And the question says, what precautions should a chartered accountant take when the client is purchasing any property to avoid any future notice under Pmla?
Madam, look here. under Sale of Goods Act, there is a provision of maximum caveat emptor. Caveat emptor, let the buyer be there. So, a person who is going to purchase the property must be careful, and immediately after purchasing the property, he must show due diligence and get the property transferred in his name through sub-registrar. That will be a bona fide issue from his angle, and that will allow him to continue with that property. And despite that, if bad luck is there, the ED officer, even if it is attached, but I am sure that ultimately they will get back that money by under section 8 subsection 7 of 8 subsection 8 of Pmla. Certain provisions have been incorporated, and the last one is that any victim of crime, because such chartered accountant will be deemed as a victim of crime. He is not aware of the offense, and if he is a victim of crime, he will get back his property during that course of trial by the special court under section 8, subsection 8, second proviso. Section 8, please advise the participant to viewer he or she should consult section 8, subsection 8 of and its second proviso.
Okay,
Thank you. Yes, next question.
So the next question is, do all agencies like IT, CBI and ED investigate simultaneously at the same time, or one agency takes over from the other and supersedes others?
Madam, as per provisions of law, all the agencies can work simultaneously. But so far as in my lecture I have clearly said that I have seen that recently a trend has come up that CBI is investigating and simultaneously ED is also investigating. I am afraid that tomorrow a day may come that if CBI files the closure report, what will happen to ED case? Matter is debatable. In that regard, I had told the participant two judgments. One judgment of Babulal Verma, Bombay High Court, another judgment of Telangana High Court of Madhu Kaneru, and I also cited the judgment of Dr. V.C. Mohan, decided by Supreme Court on 4th January 2022, which says that indeed the offence of money laundering is dependent upon predicate.
Okay, sir. Sir, I will take the last question, which says, can you explain connection and interplay of offences under Pmla and Benami Prevention Act?
There is no interplay. Benami Transaction Act is different. And Benami Transaction Act itself is not a scheduled offence. The scheduled offence is only Black Money Act, and that too section 51. So Benami Transaction Act has nothing to do. And if the properties have been attached under Benami Transaction Act and ED wants to attach it under Pmla, there is no legal bar, because there is a judgment of Honorable Supreme Court, that is, the name of the judgment is Solidaire versus Fairgrove, Solidaire, Solidaire versus Fairgrove, where Supreme Court has said when there are two special laws and they are working on same direction, the latter shall prevail over the former. So this Benami Transaction Act is of the year 1988, although vast amendment have taken place in 2016, but it shall be treated, the date of inception would be 1988, whereas Pmla, the date of inception is 1/7/2005. So many times people say that in 2016, vast amendment has taken place. So I would like to respond to them in vast amendment have also taken place in Pmla in 2019. But date of inception is material for the purposes of computing as to which law is former and which law is latter.
So thank you so much, sir, for sparing your valuable time and enlightening our member participants and other stakeholders on this subject of practical aspects during the investigation with enforcement agencies and the role of chartered accountants that they play in anti-money laundering. So thank you, sir, on behalf of the Committee on Economic, Commercial Laws and Economic Advisory, as well as on behalf of the Institute of Chartered Accountants of India. Thank you, sir.
Thank you, madam.
We thank all the participants also for attending this webinar. Thank you so much.
Thank you, madam. Thank you.
Thank you, sir.